Okay, think about it. What's on your phone right now? Your texts, your photos, basically your entire life, right? Well, in Canada, one single court case, R.V. Fearon, completely changed the game for what police can and can't see on your phone when you get arrested. Let's get into it.
So let's put you in the hot seat for a second. Imagine you're arrested. The police take your phone. Can they just start scrolling? Go through your private messages, look at your photos, check your banking app, read your emails, all without getting a warrant first? That is the exact question this whole case is about.
All right, so let's dig into the story that basically forced Canada's highest court to tackle this modern-day problem head-on. And it all starts with a man named Kevin Fearon. So, it all kicks off with an armed robbery back in July of 2009. Just hours later, the police arrest Kevin Fearon. And during that arrest, they find his cell phone. Now, here is the crucial part. They search it. Twice. And they never got a warrant. The evidence they found on that phone is what sparked a massive legal fight over our digital privacy rights that went all the way up to the Supreme Court of Canada.
So what exactly did they find that caused all this fuss? Well, they found a draft text message that started with the words, "We did it," and then asked where the stolen jewelry was. They also found a photo of a handgun, which turned out to be the same one used in the robbery. That's pretty damning evidence, right? But the question was it obtained legally? And that one simple search created this huge legal dilemma. It basically pitted a very old police power against a brand new piece of technology. Here's the core conflict. On one hand, you've got this long-standing police power called search incident to arrest. It's been around forever, and it lets them search a person they're arresting to look for weapons or evidence. But on the other hand, you have Section 8 of our Charter of Rights and Freedoms, which is supposed to protect every single one of us from unreasonable searches. So, which one wins? This whole thing really boiled down to one central question for the Supreme Court. When it comes to a search, is a smartphone just like a modern-day briefcase that police can flip through? Or is it something else entirely? Something so personal, so private, that it needs a whole different set of rules. Okay, let's get into what the judges thought. The majority of them landed on a kind of yes, but answer. They said, yes, a warrantless search could be constitutional, but only if police followed some brand new, very strict rules. Now, their thinking was pretty practical. They were looking at it from a policing perspective. Sometimes, they argued, searching a phone right away is absolutely critical. It to help them find a gun before it's used again, or track down accomplices before they get away, real-world urgent situations. So to balance that need with our privacy, the court came up with this brand new 4-part test. First off, the arrest itself has to be legal. Can't have an illegal arrest leading to a search. Second, the search has to be directly connected to why the person was arrested, like preserving evidence for that crime. Third, and this is a big one, it can't be a fishing expedition. They can't just rummage through everything. It has to be targeted. And finally, the police have to take detailed notes on exactly what they searched and why, so a judge can review their actions later. But, like I said, it wasn't a unanimous decision. Not at all. A really powerful group of dissenting judges argued for a totally different approach. Affirmed no, unless. They were convinced that our digital lives deserve way more protection. And Justice Karakatsanis, who wrote for the dissenters, just nailed their philosophy with this line: a phone isn't just a thing you own, it's a window to our inner private lives. See, their whole argument was that a phone is nothing like a briefcase. A phone holds an unbelievable amount of personal data. It tracks our every move, it can hold on to stuff we thought we deleted, and it's a gateway to even more of our information in the cloud. They argued it literally reveals our thoughts, our friendships, our core selves. So, what was their solution? Simple. The default position should always be privacy first. The police should have to get a warrant from a judge, just like they would if they wanted to search your house. The only exception? Truly urgent life or death situations, like an imminent threat. So, there you have it. 2 incredibly powerful, competing ideas about our digital privacy. One siding more with police needs, the other with our personal lives. So, who won? And what does it all mean for us today? And get this, the final decision was razor thin. It split the Supreme Court 4-3. And by that tiny, little margin, the majority's yes but approach won the day. Their 4-part test is now the law of the land for any cell phone search during an arrest in Canada.
But hold on, here is where the story takes a really interesting twist. After creating these new rules, the Supreme Court looked back at how Kevin Fearon's phone was searched, and they found that it actually violated their new rules. The police hadn't taken good enough notes. So, if the search was unconstitutional, why wasn't the evidence just tossed out? Why was his conviction upheld? Well, the answer lies in this tricky but super important part of the charter called Section 24(2). It basically says that when evidence is obtained illegally, a judge has to do a balancing act. They have to decide what would be worse for the justice system as a whole, letting in evidence that was found by breaking the rules, or letting a potentially guilty person walk free because of a police error.
And in Fearon's specific case, the court decided to let the evidence in. They said, look, back in 2009, the rules were a total gray area, so the police were acting in good faith. They also found that the privacy breach wasn't that severe, while the evidence itself, that text and photo, was totally reliable and absolutely crucial to the case. In the end, they decided that throwing out that evidence would have done more harm to the justice system than letting it in.
So, after all that legal back and forth, what is the bottom line? What does this whole landmark ruling actually mean for you and me? Here's the most important takeaway. The Fearon decision officially recognized that your phone is not just another object. It has special, heightened privacy protections under the law. But, and this is a huge but, those protections aren't absolute. They can be overridden by the needs of a police investigation when you're arrested, as long as that search follows those 4 strict rules. And all of this leaves us with a huge, lingering question. That 4-3 split on the Supreme Court shows you just how tough this balancing act really is. As our devices become even more a part of us, holding our health data, our finances, our deepest secrets, where do we, as a society, draw that line between security and privacy? Believe me, this debate is far from over.